Let me take you a little bit back in time to 1898. In the case of Cole against Cole. The case arose in colonial Lagos when, at the time when English law was gradually being introduced alongside Yoruba customary law. The testator, Mr. Cole, made a will in which he attempted to dispose of property that was held as family property under Yoruba customary law. In the will, he excluded his wife and children from inheritance, choosing instead to devise his estate to individuals outside his nuclear family. This decision was challenged by his immediate family members, particularly his wife, who argued that the property in question was family property and therefore could not be validly disposed of under a will. The issues that the court had to decide included whether the testator had the right to dispose of family property under Yoruba customary law through a will, and whether a testator can validly exclude his immediate family, his wife and children, from inheriting property held under customary law. Lastly, whether English law's doctrine of testamentary freedom overrides the constraints of customary law. The court held that the will was invalid to the extent that it purported to dispose of a family property that was governed by customary law. The testator had no legal right to will away family property without the consent of the family members or in a way that disinherited such family members. Therefore, the attempt to exclude the wife and children who were part of that family from inheritance failed, and the court held that they were entitled to the customary portion of the estate which was due to them. This confirms what I said to you earlier on, that testamentary freedom is not absolute in the Nigerian context, especially where customary law applies to specific properties. Under Yoruba family law, for instance, Yoruba customary law, for instance, family property is communally owned, and one individual, even the nominal head of the family, cannot unilaterally alienate it by a will. And so it is obvious from this that the court can actually modify a will. The court can make adjustments where a will is found not to have contained what it should contain, or where there had been fraud, where there had been manipulation, where the maker was not of sound mind, or where a custom affects the property that was purported to have been given out by a will.